So, I'm Sara Rapport. I'm a partner in a law firm, Whelan, Corrente, Flanders, Kinder, and Sickett, and we do labor and employment law and education law. And I've had the great honor of working with the South Kingstown School Department, and I'd like to say that it was because of our law firm's progressive impetus that South Kingstown took off with maybe the best policy protecting kids in the state, but I can't say that because this really came from the school committee and Dr. Stringfellow, who have been on the cutting edge, in my humble opinion, of a lot of progressive efforts to address the needs of our students. Picking up on Dusty's wonderful presentation, thank you, that was really inspiring. I'm going to give some of the legal backdrop and then shift quickly to the more practical concerns that you all are facing on a daily basis, some of which Dusty alluded to. And the legal landscape, as has been implied, is changing, although I do feel it will revert to a more steady, upward, progressive climb as we muscle through this difficult stretch. The legal landscape I'll touch upon. I'll move quickly, even though I tend to get into the details of cases, which is my profession. So I'll work really hard to move really quickly. The common issues, the strategies, and then we have a couple of question and answer case scenarios that some of you have encountered or will encounter as you move through this conversation. So the legal landscape has two components, as you know. There's federal law and there's state law. The federal law that protects students in areas of sex discrimination, which has been in the news, is Title IX. It's an old law, relatively speaking. It's the Education Amendments of 1972. And it prohibits discrimination on the basis of sex in any educational program receiving federal financial assistance, which we all do receive. Some courts have determined that Title IX's protection or prohibition on the basis of sex discrimination protects against discrimination and harassment on the basis of failure to conform to sex stereotypes and gender identity. I don't know if you've been watching the news, but in the analogous area of Title VII, which protects in the employment world, the Seventh Circuit, which is historically a somewhat more conservative circuit, recently issued a very wonderful opinion involving a teacher who was discriminated against on the basis of the fact that she was a lesbian. And the Seventh Circuit en banc, which means the entire court, all members of it, ruled that it was changing its law and ruled that the Title VII prohibition embraced sexual orientation, which has ramifications for issues of gender identity, because at the root of all of this legal analysis is the notion that it is not lawful to stereotype or to make assumptions about appropriate or proper behavior based upon assigned birth status. The DOE and the Department of Education and the Civil Rights Office for Civil Rights have been in the news, as you all know. The two big issues, the two major points are really the May 2016 guidance from the Department of Education, which very plainly made it clear at that time under Obama that gender identity was protected within the embrace of Title IX. And what that May 2016 guidance said and directed to all school committees was in no uncertain terms that Title IX prohibited discrimination on the basis of gender identity, and also that when a student notified a school administration that he or she or they asserted gender identity different from that of his or her assigned birth, the school must begin treating that student according to the preferred identity without requiring medical diagnosis or changes to identification documents. So if a student presented and said, I am asking that I'm requesting that you call me by the male pronoun, you had to honor that unless you had a really reasonable basis for believing that it was not a credible presentation. That guidance from May of 2016, it's also called the Dear Colleague letter, said that sex-segregated facilities and activities must include access for all students in accordance with the preferred gender identity. And then finally, the third point of importance in that guidance was that schools may not reveal a student's personal identifying information, so that if a school district released the transgender status, it could violate federal laws protecting students' privacy, including FERPA. As you will see in a subsequent slide, that guidance is no longer the law. In addition, there were two important decisions, one of which I'll talk about, which is the Gigi Gloucester case, which came out of Virginia. And in that case, the student, Gavin Grimm, was born female, but by 12 had identified as transgender. In his freshman year of high school, he said that he identified as male. He told his parents late in the school year in April, and he began seeing a psychologist and had hormone therapy. In his sophomore year, his mom notified the high school and school officials of the name change. He used the nurse's restroom and felt stigmatized. He requested permission to use the boys' bathroom. In December of that year, that would be his sophomore year, the school board adopted a resolution and required that all students use the restrooms and locker rooms of their biological sex. Gigi agreed, but then filed a motion for a preliminary injunction to enjoin the resolution. That is, he complied, but then he challenged it in court and claimed that that resolution by the school committee, the school board it was called, violated both the Equal Protection Clause of the US Constitution as well as Title IX. The board even had created a unisex bathroom, but Gigi argued that he felt stigmatized. The federal court at the trial level dismissed the lawsuit, and I learned this at a conference I went to. It's not in the opinion, but the judge, who was a single trial judge, dismissed the lawsuit saying, and he announced this from the bench, that transgender was a mental disorder, and he said, I had chosen to dismiss the Title IX claim. In fact, I decided that even before we started the case. So he basically took the bench and announced that he had made his decision before hearing the argument. The court relied upon the need to protect the privacy of other students. Gigi appealed to the Fourth Circuit, which is the appeals court, which reversed the lower court, and that court found that the federal regulation prohibiting schools receiving federal funds, providing that schools may require or provide separate toilet, locker room, and shower facilities on the basis of sex, but facilities provided for students of one sex shall be comparable. Essentially, the court looked at that regulation and said, on the basis of sex means gender identity, and essentially endorsed the interpretation subsequently given by or contemporaneously given by the Office of Civil Rights and the Department of Education. That's the case that went up to the Supreme Court, which very recently, as in within the past couple of months, has returned the case. There was some discussion that the Supreme Court would hear this matter and make some fairly important decisions about, among other things, the power of the Office for Civil Rights and the Department of Education to issue this interpretive guidance, which among lawyers, there was some concern, even among those of us who are progressive, that perhaps Obama had reached a little and was going to get shut down legally. But it's all moot now because the Supreme Court has returned that case to the Fourth Circuit to sort of wrangle with the interpretive questions. And more importantly, the new administration, the Trump administration, has changed course dramatically. And that's reflected in the behavior or the policy changes around another case emanating from Texas, in which Texas, joined by Alabama, Georgia, Kentucky, Louisiana, Maine, Mississippi, Oklahoma, Tennessee, West Virginia, Wisconsin, and Utah, challenged the Obama administration's implementation of that May 2016 guidance and said that Obama's cohort had overstepped itself and engaged in rulemaking. So they went into court in Texas. Texas issued what they call a nationwide preliminary injunction to stop the operation of that guidance. And initially, well, not initially, but Obama appealed that injunction preventing it from implementing the May 2016 guidance to the Fifth Circuit Court of Appeals. But that was in October, and then in November we had a new administration, which recently, within the past few months, has notified the Fifth Circuit that it did not oppose the injunction, and therefore the injunction which prohibited implementation of the May guidance is in effect. But even if Obama hadn't, or the Trump administration hadn't withdrawn its challenge, the Trump administration has taken action as of February 2017 to withdraw the May 2016 guidance. So bottom line is that as of February, the Trump administration issued a guidance, February 22nd, that said that the Dear Colleague letter of May 13, 2016 was withdrawn, and that the guidance documents the Trump administration wrote take the position that prohibitions on discrimination on the basis of sex and its implementing regulations require access to sex-segregated facilities based on gender identity. The guidance documents do not, however, contain extensive legal analysis or explain how the position is consistent with the express language of Title IX, which in 1972 wasn't thinking about sexual orientation or gender identity. So the May 16, 2016 guidance is a dead letter, and the federal law is not in a state of any kind of activity. That said, the good news is that state law here in Rhode Island is very powerful, and it continues to exist and protect public accommodations on the basis, or access to public accommodations, which includes schools, on the basis of gender identity. The other good news is that the Department of Education has issued a very powerful guidance, which, to the extent it relies upon federal law, may be of questionable import, but keep in mind that this state law is there for us to use. So I would argue that all of the protections that the guidance articulates, which rely upon federal law, can be buttressed by state law, and therefore hold steady and assume that the guidance is still, the RIDE guidance is still properly articulating the state of law in this state. So these are the specific issues, and I really will ask that our school committee and superintendent talk to these more specifically. But these are the issues that affect us on a day-to-day basis: the use of chosen names and pronouns, student confidentiality and records, use of restrooms and locker rooms, sports, parent reactions, and harassment. The important point that I hope you can take away is to anticipate, plan, and think about this ahead of time. There are a host of issues that come up in all of these circumstances, and what South Kingstown has done is to develop a document-driven plan which students can use with parents or without parents to anticipate some of these issues as they surface. The policy that South Kingstown has developed addresses all of these issues, and we would be happy to talk more specifically about that. But the central message is really that in all of these policy-making decisions, you need to be clear about a few points. And I'll just articulate the key elements of the South Kingstown policy, which can then be used to more completely talk about them in the context of these scenarios. The first is that gender-based harassment can and does include harassment on the basis of gender identity. Therefore, in South Kingstown, the policy explicitly says that in addition to prohibitions on harassment, which are defined in part by state law, gender-based harassment can include acts of verbal, nonverbal, physical aggression, intimidation, or hostility based on sex stereotyping. So South Kingstown has really captured the essence of the legal definition, which is generating so much of this conversation in the courts. It's stereotyping. It's making assumptions about the nexus between how a person presents and what you think they should say, do, and how they should behave. Thus, harassment of a student for failing to conform to stereotypical notions of masculinity and femininity constitutes sex discrimination. Gender-based harassment can rise to a violation when such conduct, and this is clear definition of Title IX law, denies or limits a student's ability to receive educational aid, benefits, services, or treatment, or when such conduct is sufficiently severe, persistent, or pervasive that it has the purpose or effect of substantially interfering with the student's ability to participate in programs. The South Kingstown policy also gives the definitions, which are in the RIDE guidance as well, of gender expression, gender identity, gender nonconforming, sexual orientation, transgender, and transition. One point that is increasingly common in schools, and I happen to know this because I have two kids myself, is that a very important facet of the way kids are presenting themselves is gender nonconforming, which means that gender expression is a fluid concept, not binary, and kids are sort of grappling with where in the range they feel comfortable and feel that they are. The other issues for school districts covered in the South Kingstown policy address privacy and confidentiality. You're dealing with a very sensitive area whereby if you disclose, it could violate confidentiality, or if you fail to honor, it could violate confidentiality. So you have to be really clear in developing your student plan where the student wants you to disclose and when. It's very fluid and it's very specific, and you really need to sit down with the student ahead of time and talk through with the student and his or her parents who are the people who get to know, who are the people who don't get to know. So use of names and pronouns and student records also implicate issues of privacy, and those are very, very complicated. Gender segregated facilities, Dusty spoke about. South Kingstown policy articulates it perfectly. Under no circumstance should any student be required to use segregated facilities that are inconsistent with their gender identity. However, the district shall designate single occupant school facilities if the student prefers it. These single occupant can be useful for the transgender student, or it could be useful for students who may have issues being in a locker room with transgender students. You can't force it, but you can make it available to those other students if they really, forcefully object to being in that space. The other thing is training and professional development, and that is imperative. It's really imperative for the school to take a proactive stance. I know Dusty alluded to expulsion as a way of addressing a behavior that is either a microaggression or a macroaggression perpetrated by one student against another, but some of the literature suggests that a more effective approach that would have less retaliatory consequences for the kids who are transitioning or transgender is to use restorative justice or to use training, education, and more, depending upon the students' and parents' willingness to share a more sort of constructive approach to educating kids who can be very mean but also very supportive of each other.